I am excited. Let me take down this. Hold one moment. Let me take this overlay down real quick. Let's see here. We got Tanya with the T in the building. What's up, Tanya? How are you?
Hey, how's it going? Hi.
I'm doing great. I'm doing great. Thank you for joining me. Let me
Thanks
see
for
who
having
in here. Let's see who rocking with me. We got Tammy Beckham in the building. We got Conchita in the building. Hello, Karen Goff. Hello, rocking with the truth. Thomas Reese, Cherie Harris, Angela Anderson, Laura Zeffin. Hello. Let's see here. Shay, what up, Shay? Shay said, hey, I'm gonna be in the bushes. So icy. Let me see here. I'm McQueen, Davis Campos, Todd Robinson. How you doing? Andrea Wilkins. Hello. TLM ATL. Hello. And let me see here. Okay, Karen Johnson and Sharon Spiller. Everybody else to come in. Welcome to the channel. Y'all, we are at the closing arguments. We are at the closing arguments. I specifically, hey, Tabo, I called Tanya. I said, Tanya, this is going to be your night because this is Bonjean's opportunity to seal it for R. Kelly, to try to convince the jury that this man is not guilty. And so it's going to start off with a little bit of back and forth, but then it's going to be your time to shine. This is going to be your night. So,
all right.
So I think it'll be enough to keep you up, I know,
I might get mad at myself, but that's okay.
That's okay. Hey, Kelly Rogers, how you doing?
Hi, Miss
How
Rogers.
you doing? Thank you for coming in. All right, y'all. So before we get started, y'all already know what I got to do. So let's go!
1, 2, 3, welcome. 1, 2, 3, welcome to the show. Can you
energy, grab me a positive synergy. I have been doubted through life, been there and done that with trifling people who told me my style would not work. I told them they wrong, been struggling too long. This song is for you, I'm proving you wrong. Get out my way, 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 get out my way.
I love that.
Yeah.
I never get sick with that song. I love it.
Thank you. I appreciate it. Thank you. That's my baby. That's my song.
Hey, how was that movie the other night? How'd that go?
Man, listen.
I didn't go on my
listen. It went great. If you go to my community page, you'll see the director posted up a shot of one of my scenes, and it was pretty cool.
Awesome! Congratulations.
Yeah. Thank you. Appreciate it.
I can't wait.
So tonight, y'all, we're gonna get straight to this because it's gonna. I don't want it to be too late, but I want to try to put a chunk into this. So this is going to be, like I said, it's Bonjean's night. It's Bonjean's night. Lesmit 1, if you could come in, Lesmit, to help Tanya with the sleepy tea, read Bonjean, that'll be great because I know she can last for a little bit, but sooner or later. What's up, Lovers Fair? What's up, Damien? What's going on? Dat Nurse 1980. Hello. So, yes, that would be awesome if you can come in. Lesmit 1. That'd be awesome. Okay. So let me go ahead and pull this up. Let's go ahead and pull this up. And let me, let's see here. And let me share this with y'all. Let me take this one down. Take this down. And let me share my screen. Here we go. I'm going to take my picture off. Hold on. Let me do this. Okay, here we go. Awesome. Let me open it up for us. Okay, there we go. And so what I'll do is I will play all the men right now until we get help with the ladies. You can do all the ladies, and then it's going to eventually get down to. Okay, thank you, Lesmit. Lesmit should be in 10 minutes. Perfect. All right, so here we go. Let me go ahead and take this off. There we go. Okay, so we're going to go ahead and get started. If you're ready.
I'm ready.
Awesome. Okay. So here we go. All right. This here is the closing arguments, y'all. Closing arguments. So we're going to start right here. Proceedings heard in open court. The jury is out. Mr. Julian, you wanted to say something?
Yes, Judge. I'm actually going to be speaking.
Miss Pozzolo?
With help from Julian. So we have two things. The first thing is during Miss Judge's closing argument yesterday, she referenced the examination of Charles Freeman and the testimony about the lawsuit in 2009 and the mistake. Hello?
What happened?
I hear echoing.
Hold on.
Okay.
Hold on.
I think it stopped.
Okay.
Charles Freeman and the testimony about the lawsuit in 2009 and the mistake that was made saying that the lawsuit was against Kelly, Mcdavid, and Brown. That was corrected by Miss Judge on cross-examination. During my closing argument, I also stated that the lawsuit was against Kelly, Mcdavid, and Brown based on that testimony. And of course, the jury is going to be instructed that what the lawyers say is not evidence. They have been instructed of that. But the issue here, the other issue, is that there was also another mistake made with regards to the document itself. The document that Ms. Judge put on the document camera, the lawsuit cover page from 2009, is not in evidence, and it was never entered into evidence. And Ms. Judge told the jury they were going to be able to look at this document, during deliberations. So we wanted to raise that. And we think that there are a couple of options. Either the jury should be informed that the lawsuit is not in evidence, or we can admit it. We would not object to it being admitted, but we would want the whole document in. Ms. Judge showed the cover page, but the reason that there has been confusion over this.
All right. Let me ask, Ms. Judge, do you have any objection, or does anyone have any objection if we put the entire lawsuit in? Judge, we object to the entire lawsuit being put in.
So do we.
All right.
Judge, I put the cover page in to show who was sued because the government misstated the facts. I didn't object. I didn't jump up and down in front of the jury. I just impeached the witness with the cover page so that they could see the mistake and so that Freeman would see his mistake. And then besides the fact that I did that, the government still mentioned in their closing yesterday they need that cover page in. Well, Judge, the issue is that the cover page is misleading. First of all, because Brown is referenced throughout the actual lawsuit as the agent of Robert Kelly. That's the issue. So if the jury is going to be able to look at this, they should get, it is 3 pages or 4 pages. The issue.
Well, there is an objection to it. It is too late to open up the proof, so I guess you could, or you would have to just rely on the fact that the lawyers can't state facts. And there wasn't an objection raised at the time. I'm not criticizing you for not raising an objection as to time, but, I don't see where we can put a document in the evidence that was not offered during the trial. So that suggestion is out. I would suggest that we just leave the record the way it is.
Agreed.
And proceed. You can make the comment, and that's not, an evidence, or however, you want to say it. Apparently, what she issued or what she stated is true. I mean, as far as that goes, I suppose at some point I could have taken judicial notice of the records of the United States, District Court for, where was the case filed? Oh, this was in
Kansas City State.
Kansas City, yeah. I don't know if I, even do judicial notice of.
I think you can, Judge.
I don't know if I could or not. But anyway, I would suggest that we do, and I don't think any alternatives. Leave the record the way it is. You can comment, and that is not enough. What is not in evidence? That is not in evidence. And that's about it. Rely upon the fact that you told them that, they may believe that. I was just clarifying, want to clarify something, Your Honor. Since it's not in evidence, I just want to make sure that the government can't now put up for the jury in their rebuttal argument to show them the contents of this lawsuit. No, it's not before the jury. It's not in evidence, so it's too late.
during the middle of the final arguments to open up at the record. So we'll just go. I mean, it won't be the first misstated fact in the trial. I'm not specifying this trial. Not the only misstated fact that will ever be uttered. I think I've noticed them before in some of my prior trials. Are the jurors here now?
Judge, there was just one other thing. The government is trying to keep its objections during closings to a minimum, but there is one argument that keeps coming up, and it's pure jury nullification argument, that the government waited 20 years to charge the defendants. That's not accurate. We asked that Ms. Bonjean not again state that. That was stated a few times yesterday, and that's not an issue that the jury needs to be thinking about. They need to be thinking about the case. So, absolutely not, Judge. This isn't about jury nullifications. No one is arguing that they should just find these defendants not guilty because the government waited. But the delay does impact the credibility of the testimony, and it impacts the recollection, and it impacts the memory. There is another jury instruction that actually identifies a witness's memory as a factor to be considered when determining whether or not they should be believed. So the delay, frankly, is at issue. It's not about jury nullification. It's about the impact of a 25-year delay on their proofs, and that's fair game.
And there is a statute of limitations problem, Judge.
And that's fine for them to make those arguments about the length of time, the events being a long time ago. But saying that the government waited to charge as if we could charge this in 2008, they could have charged when we don't have the tape from Charles Freeman.
Wait. We talked about this a couple of days ago. When you respond to an argument, you respond to me. Only if I request a response. Otherwise, let's keep the decorum great. Now, it's been really good on the whole trial with a few minor exceptions. But I know that we can get interested. I know we can get interested in the particular issue, So I'm trying to remember now what we're arguing about.
They're arguing that I shouldn't be able to mention delay because of...
Oh, the delay. Delay in bringing the case. I think that I don't think that you can blame the government and say the government and that would be a form of nullification. But you can certainly state how difficult it is because it took so long to bring the charges that, that the witness are dead or whatever. The whole idea behind the statute of limitations, which is one of the arguments that's, of course, it is before the court, but I think it's inappropriate to blame the government by saying that they unfairly have by intimating. Am I saying that word right?
Yeah, looks like
intimating that or stating that it's unfair for the government to wait this long to bring the charges. It's fair to say that the difficulties that arise because of the delay, but not to impute wrongdoing on the part of the government. So let's do it that way.
And Judge?
Anything else?
There is. One moment here.
There is one more thing, Your Honor. And this is hopefully less controversial. The parties have agreed to waive the issue of forfeiture. So there are forfeiture allegations in the indictment. I just handed to Ms. Foster what I believe might have handed to you signed forfeiture waivers by all of the parties. So we just wanted to bring that to your attention before we send the jury out, that the jury will not be asked to consider that issue. If any defendant is found guilty, it will be up to you to determine the issue of forfeiture.
Is that correct on the part of all the defendants?
Yes, Your Honor.
Yes.
All right.
Yes.
All right, so that's taken care of. All right, are we ready?
Yes, sir.
All right. Ms. Bonjean, you have an hour, 45 minutes. The government has 57 minutes, and I have about 20 minutes for the instructions.
Judge, I'll try to come in under my time.
Jury is in.
Please be seated. Well, we left off yesterday, we heard the closing argument. The opening. Did we hit? Am I in the right place? We heard. Hold on.
Did you do closings yesterday?
We got rid of Mcdavid, right?
I
Now,
felt.
Did we? We didn't have a. Hold on.
So the government's supposed to go first, then Bonjean goes last before the government goes back. So then
let's go last. So we are.
Oh, so you missed a day probably. Closing arguments were 2 full days. I was like, wow, I slept through all of that.
Yeah. Hold on. 9/9. Wasn't there like a 9/12?
I could pull up my calendar. Hold on 1 second. Let's see.
Hold on. I got it. Let me see. Sent. Hold on. 9. Yep. Sure was. This is it. Okay, I'm sending it to myself now. I'm about to say, how we get to Bonjean already?
I was like, wow, I was sleeping like sleeping.
You were sleeping your butt off. All right, hold on.
I feel so tired if I really got to sleep that much.
All right, hold on. Let me pull this.
I kind of just figured that we were at the end of.
I know we finished because I was like, I know that was the 12th. Where the heck are we at the 13th already? Hold on, let me.
Yeah, because he ended on a Friday.
Right.
And then the court was closed on that Monday, remember?
Right.
And then it's closing argument. Yeah, okay.
Okay, share. There we go. Hold on, I think someone's in. CJ!
Hey,
Hi,
CJ.
Hello. Good. How are you?
Hold on, Tang. You cut off her. You cut off her shining moment. We gotta do that again. Hey, CJ.
Hi, guys.
There we go. All right, awesome. All right, so okay, great. So now CJ's here, so she can help with the government reading. I think we're on the right page now. Okay, so this right here is 3648. So let's go ahead and start right here at the top. All right.
And the whole chat was just letting us go to it, right?
I know they were just
Excuse me. I was backstage saying stuff like, no, guys, no.
The chat was just like, man, let's get it. All right, so here we go. Hold on, let me pull this up. There we go. Okay, perfect. All right, here we go. Let's get it. Over the weekend, there was only one motion filed. That was the government's to preclude reading of the trial transcripts. It was responded to by the defendants. It's clearly within my discretion, and since we have had a daily copy, I'm going to deny the government's motion to preclude reading the trial transcripts. The other thing probably that we should discuss is, and I know that the defendants do not want to have the government give its final rebuttal now, but I've been, trying to do the mathematics, and I just don't see how we're going to be able to get 7. What is it? 3 plus 3 plus 1, 7 hours of arguments, plus instructions, without killing the jury and without killing me. So we'll go as far as we can today, and I appreciate that the defendants wouldn't want that. But Judge, I don't know how we can avoid it. Judge, I think we have a proposal as far as the defense goes. Today, our plan is to proceed. I'm going to go first, arguing for the defense, and I believe Ms. Judge is going to go after I do. And my suggestion, in light of the time frame, is to let Ms. Bonjean argument and the rebuttal both be done tomorrow. I think that's fair to both sides, and we're comfortable with that. If we
If we can have that to be the procedure, if the government doesn't, I'll have a problem with that.
I don't think we can do that. That would probably not be enough saving time. We'll see. We'll just have to see how it goes.
Okay.
Certainly, I would not be able to instruct the jury today on all the arguments, but if you don't have the time, much time as you requested and I allow, perhaps it could fit in. But I really don't, see that as a viable possibility fitting them all in today. Certainly, we'll have, at least to instruct them tomorrow. So the jury will have to come back. So it won't, or so I won't excuse any of the alternates until after I've instructed the jury. So they will all come back in case something happens overnight.
And Judge, I appreciate that we want to get as far as we can, but I do have to apprise the court. And it is rather important that I indicated that I would try to limit my arguments to 90 minutes, just as my defense counsel, my colleagues here, but there are 13 counts in.
Hey, Lesmond.
Hello, Atmos. Hello,
Thank you,
everybody.
Howdy.
No problem.
Hello.
All right.
This indictment for Mr. Kelly, there are complex concepts, not just in the obstruction counts, but also the inducement counts, which have definitions within definitions. My concern is that we are going to get to the end of the day, and I cannot be rushed with a fatigued jury. That would not be fair to Mr. Kelly.
Well, if we're at 4:00 or something like that, I'm not going to require you to start your argument. But if it's at 3:00, I'll just have to see how it plays out. I don't know how long you. I know what I gave you, and whether you take all that time is.
On that subject, Judge, I have an argument with Miss Judge. My argument will be a bit longer than 90 minutes, but she has agreed to allot me her time so that we will be using the same amount of time, but I'll be speaking longer.
All right. Well, that does not give me a pensive belief that we'll be finished today.
I knew it. I knew it wouldn't, to be honest.
Well, do the best we can. I think, it's going to be absolutely necessary that the government's rebuttal be tomorrow.
Yes, Judge.
Let's do, CJ, if you could be Miss Pizzolo. Oh, how about this? You could be the government, all the government people. Lesmond, you could be Miss Judge. And let me see, Miss Judge don't say much. Miss Judge, and I'll have you go back and forth with Bonji and the government, okay? If you could stay.
One person talking in a minute. Only the government's going to be talking in a minute.
I know, so we'll just go back and forth. I'll switch y'all in and out just so nobody gets burnt out.
Okay. Yes, Judge. And the one thing the government's requesting is just we want an understanding of what the time limits are for the parties, because that affects obviously how long I'm going to spend right now. So can we just confirm that what the time limits are in place? I believe on Friday you allotted the government 3 hours combined.
Yes.
And then each defendant 90 minutes. So I just want to make sure.
Actually, can I give 90 minutes to? I thought, Miss Judge, you only asked for an hour.
Yes, and there's one count at issue for that defendant.
Yes.
And Judge, to be clear, I need 2 hours. I have 13 counts. It's not fair that, for instance, that my counterparts and they should be able to obviously take the time they need to, but Miss Judge has 1 count. Mcdavid has 4 counts. I have 13 counts to deal with. I tried very hard, and I have been, frankly, I think throughout this trial pretty quick. I have adopted when I could, and I will continue since I'm following in the wake of Mr. Brindley not to redo any argument, but I may also be in a position of having to address arguments that Mr. Mcdavid makes and Mr. Brown make that I have to address because there is some antagonism here in these defenses. I initially said I needed 2 hours. I would try to keep it to 90 minutes, but I just want to let the court know if I'm being realistic, it is going to take me 2 hours to get through it. If I can get through it quicker, I will, but I cannot limit myself to 90 minutes with 13 counts, including theories, legal theories that none of my co-defendants have to deal with. So we are talking about instructions. We are talking about I have to get into wade into areas that is not an area that they will even touching.
Let me ask, Miss Judge, how much time do you expect to take?
Less than an hour, 48 minutes to an hour at the most.
45 minutes? So that gives us 15 minutes to play with.
Well, those I've already sold to Bo.
That's right, Judge. I've already got those minutes.
All right. Ms. Bonjean, I'll give you another 15 minutes.
Okay.
All right.
Judge, can the government also receive another 15 minutes?
No. You guys get 3 hours. That will be enough. Plus the fact that you get the last word, which, they have to anticipate everything you're going to say. So 3 hours for the government. You can break it up any way you want. Let's see, 105 minutes for Mcdavid and Kelly and 45 minutes for Brown. All right, let's get the jury in and get started.
Can we do a quick just tech test since we're using a different microphone and make sure my computer is set up if we could?
Say again what you just asked.
I'm working with your law clerk to make sure that the tech sound and the laptops is synced before the jury comes in, if that's okay.
Well, where are you going to stand for the final arguments?
Right here.
Right here? Oh, okay. All sides will speak from that podium, I guess. I don't see any room for another one. So let's get the jury in and let's get started. Who's going to start for the government?
I am, Your Honor.
All right. If I may make a suggestion, which probably wouldn't be followed, but 99% of objections that the argument misstates the record are overruled. And if, both sides, in order to speed things along, if we can avoid making arguments that misstates the record, because my automatic response is up to the jurors to decide what is in the record. So I just, want to say that it will help things speed along if we don't, make any of that particular objection during the arguments of the respective counsels. That's a suggestion. Hopefully, you'll follow it.
Jury is coming in. Jury is in.
Please be seated. Good morning, members of the jury. As of last Friday, as I mentioned, the government, all sides resided. We're now ready for closing arguments. This is the opportunity for the lawyers to have to go over the evidence and testimony with you and to suggest to you how you should interpret the evidence that you've heard over the past 4 weeks or so. And they're designed to be helpful to you and allow each side to present the theories that they espouse to suggest how you should decide the case. They are permitted and encouraged, obviously, to argue because these are closing arguments. One caution is that, what the attorneys say is not evidence. So that if any attorney makes an assertion as to what particular item of evidence was or it's your collective recollection that isn't the way it is or it was, then of course you follow your collective recollections and not what the attorneys say, because again, they are not allowed to give evidence. So the government, having the burden of proof, the government goes first. You'll then hear from the defendants, and then the government will be permitted to file a rebuttal argument at the very end. When I will instruct you as to the law, I'm sorry, I had to yawn. I didn't get much sleep yesterday. Then you will retire to consider your verdicts. So at this time, the government may proceed. Ms. Peloso, you may argue on behalf of the government.
Thank you, Your Honor.
Opening agreement, opening argument on behalf of the plaintiff by Ms. Pozzolo.
Jane, a 14-year-old child abused by Robert Kelly, who recorded the abuse in his bedroom, on his living room floor, in the log cabin room. Who does this? And who covers it up? These men. These three men. Robert Kelly, the man who used his position as Jane's godfather to molest her. He took advantage of his fame, of his position of power over Jane and her family. He took advantage of Jane's youth. He repeatedly abused her. He performed degrading acts upon her for his own sick pleasure. Daryl Mcdavid, Kelly's business manager, the man who knew how devastating it would be if those tapes of Kelly having sex with Jane became public. The man who knew that thousands of dollars would need to be paid to keep those tapes a secret, and he handled that money. June Brown, Kelly's assistant, the man that Kelly and Mcdavid trusted to make sure that all the necessary pieces were in place to get those tapes back. Book the hotels, get Keith and Lisa to Chicago, get the cash needed to pay Keith and Lisa. Kelly and his team, they did their level best to recover the videotapes, to keep the truth about Jane's abuse a secret for many years, to cover up the fact that Robert Kelly, R. Kelly, the R&B superstar, is actually a sexual predator. They did their best. But in the end, they failed. We are here today because those tapes that they concealed for 20 years are no longer their secret. You have seen the tapes. You have seen what Kelly did to Jane. And you have heard from Jane. She was brave enough to come forward after all these years and tell you what happened to her. You heard from other women that Robert Kelly abused when they were minors. And you heard about the cover-up. You heard about the hundreds of thousands of dollars that these men spent in order to keep those tapes concealed and out of the public and out of law enforcement's hands. And based on all this conduct, these defendants are charged with these offenses. I'm going to go through the evidence that you saw and heard during this trial, and I will show you how the evidence proves the defendants guilty of each one of the 13 charges in the indictment beyond a reasonable doubt. And the charges fall into three main groups. Group 1 are the charges that related to Kelly's sexual exploitation of Jane in videos 1, 2, 3, and 4. Group 2 are the conspiracy charges. There were 2 conspiracies charged in this case. Count 5, Robert Kelly and Daryl Mcdavid are charged with conspiring to obstruct justice. And that conspiracy began in 2000 when DCFS and CPD first began investigating allegations that Kelly was abusing Jane. And that conspiracy continued all the way to 2019 when this case was charged. Count 6, Robert Kelly, Daryl Mcdavid, June Brown, charged with conspiring to receive child pornography. And this conspiracy has a shorter time frame than the conspiracy to obstruct justice. The conspiracy in count 6 began in 2001 and continued through 2007. Now, count 7 and 8 are not conspiracy charges, but they're included in this group because the evidence for those counts overlaps with count 6. As I will explain more later, count 7 and 8 charge Robert Kelly and Daryl Mcdavid with receiving child pornography on 2 separate occasions. 2001 for count 7 and 2007 for count 8. So, Kelly and Mcdavid are both charged with conspiring to receive child pornography, as well as 2 substantive counts of receiving child pornography. In Group 3, Robert Kelly is charged with enticing 5 minors to engage in sexual activity, and each girl that he has abused has their own count. Now, there's a lot of ground to cover here, and I'm going to tackle these charges one group at a time. But before I do that, this is a high-level timeline of some of the events that you heard about during this trial. And you heard a lot of evidence in this trial, and it was not presented chronologically to you. Before I dive in to discuss the facts, this timeline gives you a general overview of what was happening between the late 90s and 2008. On the top portion of this timeline are the sexual conduct allegations related to Jane, Nia, Tracy, Brittany, Pauline, and the timing of the charges against Kelly related to Jane and the log cabin video. And on the bottom, those are the events that were taking place out of the public's eye, related to the other videos of Jane that Lisa took from Kelly's gym bag around 2000. And from this timeline, you can see how crucial it was to keep those other videos of Jane concealed while Kelly's child pornography trial was going on. It was essential that Mcdavid and Kelly keep the lid on this other information so as not to bolster the state's case against Kelly in any way. And as I continue through my argument today, I'm going to break this timeline down into smaller pieces. Let's get started with group 1, the videos of Jane and Robert Kelly. Kelly has been charged with 4 counts for his sexual exploitation of Jane in videos 1, 2, 3, and 4. And here are the elements for those counts. There are 3 elements. In order to find Kelly guilty of counts 1 through 4, the government must prove each of these elements beyond a reasonable doubt. I'm going to go through each of these counts one at a time, but before I do, I want to make something crystal clear. The entire videos 1, 2, and 3, are in evidence. They are available to you. During this trial, you were shown clips from those videos. The clips, Jane's testimony, and other evidence in this case is sufficient to find Robert Kelly guilty of counts 1 through 3. But if you need to see the clips again, or there's other portions of those videos that you feel like you need to see, you can do that. They are in evidence as government's exhibits 1 and 2. Now, the first video you were shown during the trial was video 3, and that was a scene of Jane and Kelly in the bedroom. Jane was wearing that white lingerie, and Jane testified that she was 14 years old at the time that Kelly filmed that video. And Jane also testified that this video was filmed in Kelly's bedroom at his house located at 1010 West George Street in Chicago. Remember, Kelly sold the George Street house in December of 2001. And Jane was 17 years old at that time that Kelly sold that house. So what that means is, if Jane is the person in video 3, then she had to have been a minor at the time that video was filmed. And you know it was Jane in video 3 because she testified that she watched that video. She remembered that day. She was the girl in the video. You saw the video. You saw Jane in video 3. And you saw how Kelly was directing Jane to do and say certain things as he sexually abused her. In one of those clips, Kelly instructed Jane to talk about his penis. And on the video, Jane said that Kelly told her he was going to stick it in her vagina one day when it's wide open for you, Daddy. And Kelly told Jane, talk louder, and she repeated, when it get wide open for you, Daddy. And Jane said, you said if I keep practicing, Daddy. That clip was Government Exhibit 3G. In video 3, Kelly induced Jane to take part in sexually explicit conduct, as stated here in the second element. And there's a definition of what sexually explicit conduct means. You saw on video 3 how Kelly used Jane to simulate sexual intercourse. You know there was not actual intercourse in video 3 because, as Jane told you, Kelly did not take her virginity until she was 15 years old. You saw clips of Kelly and Jane engaged in oral sex acts in video 3. If you add up all the clips that you saw, video 3, just video 3, those clips amount to less than 7 minutes in length. The entire sexual encounter in video 3 was 21 minutes and 30 seconds. 21 minutes and 30 seconds of abuse. If you look at the third element for counts 1 through 4, that's the element that deals with interstate commerce. And again, there's a definition for interstate commerce that applies to multiple counts that you'll be considering in the indictment. Interstate commerce means commerce between different states, territories, and possessions of the United States. The visual depiction of Jane and Kelly in the bedroom was mailed or actually transported across state lines. And you know this because that video was filmed in Chicago. And after that video was made, Charles Freeman recovered that video in Georgia, transported it to Kansas City, where he gave a copy to Mcdavid and Palladino. And Charles Freeman kept a copy in Kansas City for many years. And you also heard that Lisa Van Allen mailed video 3 to Keith Morrell in Kansas City. That video crossed state lines, and the third element here is met. The government has proven all of the elements for count 3 involving video 3 beyond a reasonable doubt. Turning to count 2, which charges Kelly with production of the depiction video 2. This is the scene from the black and white checkered living room floor at Kelly's house on George Street. Again, the house that Kelly sold well before Jane turned 18 years old. And Jane testified about when the scene was filmed. She told you she was 14 years old. She described how Kelly gave her champagne to drink before using her to film this video. Not only that, Kelly was playing a pornography video on the projector screen above where Jane was positioned on the living room floor. These are some of the things that Robert Kelly did to entice Jane to engage in sexually explicit conduct for the purpose of producing video 2. Kelly performed oral sex on Jane, and while he did that, he instructed her to talk about her 14-year-old vagina repeatedly. You saw those clips. They're Government's Exhibit 2C and 2E. And you saw some of the other things that this 14-year-old child had to endure during this scene, video 2. Kelly urinated on Jane's vagina. And when he did that to her, Kelly referred to Jane's 14-year-old asshole. That child who had no prior sexual experiences in her life was forced to lay on that floor while that man sitting right over there urinated on her. That degrading act is forever captured on that video. Her abuse is forever memorialized because that's what Robert Kelly does. You saw in video 2 how Kelly repositioned the camera, how he continued to move it closer to Jane, how he zoomed the shot in on her body. The clips of video 2 that you saw add up to less than 6 minutes. 6 minutes is what you saw. Kelly's abuse of Jane in video 2 lasted for 21 minutes and 30 seconds. The visual depiction of Jane and Kelly on the black and white checkered floor was mailed or actually transported across state lines. And again, you know this because it was filmed in Chicago, and Charles Freeman initially recovered it in Georgia and transported to Kansas City, where he had it for many years. He kept a copy in Kansas City. And you know this because Lisa Van Allen mailed video 2 to Keith Morrell in Kansas City. The government has proven all the elements for count 2 involving video 2 beyond a reasonable doubt. So moving on to count 1, which is video 1. This is the scene from the log cabin room at Kelly's house on West George Street. Jane testified that she was 14 years old at the time that Kelly filmed this video. And again, because it was filmed in that distinct room on George Street, you know that Jane had to be under the age of 18. On top of all the evidence about Jane's age at the time of video 1, you have other evidence of Jane's age in video 1. You have Jane's mom, Susan's testimony about this very video. Susan testified that she was shown the visual depiction of Jane and Kelly in the log cabin room during her testimony in the Cook County grand jury in May of 2002. And Jane was 17 years old in May of 2002. Susan testified that prior to this trial, she was shown the video on the disc marked as Government Exhibit 1. That's the disc that contains the visual depiction of video 1. And Susan testified that the depiction is the same one she viewed during her grand jury testimony. And Detective Everett testified similarly. Prior to this trial, this one here, he was shown Government Exhibit 1. And he told you that that video appeared to be the same video that he viewed back in 2002 when he was investigating the case for CPD. During this trial, you saw clips of video 1. You saw the clip from the beginning of this video where Kelly is first setting up his scene. This clip where Kelly is clothed and seated on the bench in the log cabin room. Kelly was making sure that the camera was properly positioned, that he would have a clear shot of Jane. And then Jane is in the frame. You saw Kelly hand castor Jane before instructing her to give him oral sex. And during her testimony, Jane explained that Kelly handed her the money because, as she told you, if anybody saw the tape or it was released for some reason, he wanted it to appear as if I was like a prostitute. Robert Kelly made that 14-year-old girl feel like a prostitute. And you saw during Jane's testimony over 20 years later how much pain that still causes her to this day. Who does that? Who uses a 14-year-old child to film a video like this? This man, Robert Kelly. Just like in videos 2 and 3, Kelly is the director of video 1. He's moving around the room with the camera, directing Jane on what to do with her body, how to dance sexually for him. And near the end of the video, you saw a clip of Kelly urinating on Jane's face and in Jane's mouth. The clips of video 1 that you saw added up to less than 5 minutes in length. Kelly's abuse of Jane in video 1 lasted for 26 minutes and 42 seconds. Kelly enticed Jane to engage in sex acts with him for 26 minutes and 42 seconds. This is the longest of the 3 videos of Jane that were admitted into evidence. And the visual depiction of Jane on video 1 was transported outside of Illinois. And you know this because you heard testimony from a witness who works for the National Center for Missing and Exploited Children, NCMEC. She told you that she reviewed video 1 and that submissions of that visual depiction of Jane in the log cabin room have been received from other states, including Maryland and Wisconsin. The government has met its burden on proving Robert Kelly guilty of count 1 beyond a reasonable doubt. Now, let's talk about video 4, which is the video included in count 4 of this indictment. These 3 same elements apply. You did not see clips from a video 4 during this trial, but you heard a lot of testimony about that video. Video 4 is a depiction of Jane, Lisa Van Allen, and Kelly having a threesome in the log cabin room at the George Street house. Lisa told you that the first time she met Jane was in the log cabin room, when Kelly wanted to film a threesome of himself, Lisa, and Jane. And Lisa described seeing Kelly set up the video camera. And in terms of timing, Lisa testified that this threesome happened between 1998 and 1999. And Jane told you about this video. She told you she was 14 years old at the time that she had the threesome with Lisa and Kelly in the log cabin room. Jane was 14 years old between 1998 and 1999. And as I have said a few times now, the location of all these videos proves that they were filmed while Jane was a minor. All 4 videos were filmed at Kelly's house on George Street, the house he sold to Matthew Hulzer in late 2001, when Jane was just 17 years old. And Jane and Lisa both testified about what happened in the log room on the day Kelly made video 4. They were both there. They remember that day. And Lisa testified before they had sex, she saw Kelly set up his video camera on the tripod. Kelly was directing her and Jane on what to do in the video, how to move, kiss, and moan for the camera. This wasn't a video of Lisa, Kelly, and another adult woman. This was a video of Lisa, Kelly, and Jane.
Thank you so much, CJ. I'm gonna pause. I'm gonna sub you out. Great freaking job, man. This is y'all. This is, oh my god. Your voice is perfect, because like this is so triggering. I know this is hard for a lot of people to listen to, but stuff like this and bringing everything together is why we support these young women.
Absolutely.
Okay. Yes, they told some lies. Yes, they forgot about some stuff from 20 years ago. Yes, that's true. But that does not give anybody the right to do what this man did to these women. I don't give a damn how much money he had, how much fame he had, how much stardom he had. He looked for vulnerable, young, black women and used them as freaking trash. He used them for a freaking hole to stick his fucking herpes-infested dick in. To piss on them like they're freaking urinals. I don't feel sorry at all. Hope they give his ass 190 freaking years and he never gets out. These things that are being read are the facts about this case. This is what this man did to these freaking women.
Girls.
Lisa Van Allen is a woman. They're women now.
Yes.
But girls when they was girls.
And if this is able to reach one person, that at least one person that can get the courage to do what these ladies did, or stand up for themselves and say, no, this is not okay. You're not supposed to do this to me.
Joy.
And we did something good for this,
Joy, I know you are out there listening to this video. Joy, please, either go home or please reach out to your mom and daddy. Please, even if it's just a text or email, if you're ashamed because of what this man has now been found guilty of, and you may feel like you're the last one standing. And listen, there's no shame in releasing and freeing yourself. We love you over here.
And you are not obligated to take care of that man.
Exactly. So it don't matter what these freaking R. Kelly supporters say and all this kind of stuff. We love you and we support you no matter what. Please go home. Either go home or reach out to home. Okay. Lesmond 1, if you will please jump in and please read this here, please.
And as I just went over, Jane testified she was the girl in videos 1, 2, and 3. She saw those videos. They are videos of Jane, and Jane's testimony about videos 1, 2, and 3 is confirmed by the actual videos themselves. Jane is also telling you that Kelly made a video of her, Lisa, and Kelly in the log cabin room around the same time that videos 1, 2, and 3 were filmed, when Jane was 14 years old. So Lisa's testimony about video 4 is confirmed by Jane, and Jane's testimony about the videos that Kelly made is confirmed by multiple videos that depict Jane when she was 14. So the testimony about video 4, where and when it was filmed, and that it was Lisa and Jane in that video, all links up. Video 4 is real. It was filmed by this man sitting right over there, Robert Kelly, and it was filmed when Jane was 14 years old. And as with videos 2 and 3, it was actually transported across state lines when Lisa sent it to Keith Morrell in Kansas City. The government has met its burden of proving Robert Kelly guilty of count 4 beyond a reasonable doubt. So, I just went over 4 videos that Robert Kelly produced of Jane engaging in sex acts at his direction. 4 videos containing child pornography that were filmed between 1998 and 1999, when Jane was 14. So, now let's transition to the time period after Kelly made those videos. The time period when the defendants learned that the videos of Jane's were leaked. 2001. The videos are out there and the defendants need to act. And this is where the conspiracy charges come into play. Now, yes, Robert Kelly is the person preying on young girls, enticing them to have sex with him. He is the one filming his sexual abuse of 14-year-old Jane. But when the tapes get out, Kelly needs help. He cannot manage that situation all on his own. In early 2000s, Robert Kelly was a celebrity. He was in the public eye. He had just performed at the Grammys, and as Mr. Mcdavid testified at length about, he was getting ready to perform at the Olympics. His star was rising higher and higher, taking him to a whole new level of success. If the tapes get out and victims like Jane confirm that he was having sex with children, that would destroy his career. He could not have that happen. So he turned to Daryl Mcdavid and June Brown, and they agreed to work together. And by agreeing to work together to get the tapes back and prevent Jane from cooperating with the pending case, the defendants conspired to commit crimes. And I have the time frames for each of the conspiracies listed here on the slide. The facts that prove Kelly and Mcdavid guilty of count 5 and the facts that prove Kelly, Mcdavid, and Brown guilty of count 6 overlap a great deal. Before getting into those facts that prove the defendants guilty of the conspiracy charges, let's talk about what a conspiracy is. A conspiracy is an express or implied agreement between 2 or more persons to commit a crime, and you'll get this instruction. So let's jump into the facts starting in 2000 when the conspiracy to obstruct justice began. April 2000, DCFS interviewed Jane and her parents and Jane was 15 years old at the time of this interview. Jane testified that back at the time of this interview, she denied having any sexual contact with Kelly because he had instilled in her how important it was to keep the relationship a secret. And Jane did not want her parents to know what was going on. December 2000, Detective Everett interviewed Jane and her parents. Jane had just turned 16 years old at the time of this interview. Detective Everett and Jane both testified about this interview. Everett testified that Jane denied the abuse and told him Kelly was her godfather and would not do anything like that to her. And Everett closed his investigation as unfounded. Jane told you after her interview with CPD, she told Robert Kelly about it. And she testified that Kelly wanted to know what type of questions they asked her, how she answered them. And Kelly told her she did a good job and handled everything correctly. 2000. Lisa Van Allen took the tape containing videos 2, 3, and 4 and sent it to Keith Morrell. After Lisa took the tape, Charles Freeman enters the picture, and I'll talk more about his involvement later. But at this juncture, it is important to note that he had a contract with Jack Palladino about recovering a videotape for Kelly. That contract was dated August 21st, 2001, and you saw that document several times during this trial. So, setting aside for a moment all of the details about where Freeman recovered the video, where he met with Palladino and Mcdavid to turn over the video and collect payment, how many individual phone calls they had, etc. There's no dispute whatsoever that in 2001, Charles Freeman was hired to recover a videotape for Kelly. And Freeman told you that it was Robert Kelly who first reached out to him directly about this. Freeman testified that in 2001, he received a phone call from Kelly, and Kelly called Freeman and told him that he needed Freeman's help recovering some stolen tapes. And Kelly told Freeman that Darryl Mcdavid and an investigator would give him a call.
Thank you very much, Lesmond One. Tanya, can you jump in for me, please? 14.
Sure. So, to recap, Kelly calls Freeman. Freeman agrees to help Kelly recover the stolen tape, and Kelly tells Freeman to deal with Darryl Mcdavid and the investigator going forward. And that's exactly what happened. Initial contact by Kelly to get Freeman on board. Handoff to Darryl to handle the business of getting the tape back. And this call from Kelly to Freeman came on the heels of Lisa taking the tape from Kelly's gym bag. Is that a coincidence? No. This is one example of how you know you can rely on what Freeman told you, of how you know you can rely on what Lisa told you about when she took the tape and what was on it. The sequence of events adds up and it tracks. And here's Freeman's contract from 2001 in black and white. It's an agreement for reward and expenses. And the first paragraph says it will memorialize the reward and expense agreement between Charles Freeman and Jack Palladino on behalf of his client. And you know who Palladino's client was? It was Robert Kelly. The second paragraph for the recovery and return of certain original stolen items, one original performance tape, and what has been represented as the sole copy. Now, in order to get his reward of $100,000 and the expenses of up to $40,000, Freeman had to do two main things here. He had to turn over the original and sole copy of the tape to Jack Palladino, and he had to pass a polygraph and/or PSE examination concerning the truthfulness of Freeman's representation that the stolen items he recovered were all the material that existed and that he knows of no other copies. Last paragraph. As you know, a common theme throughout this entire case is confidentiality, When you are dealing with child pornography, confidentiality, secrecy is key. So the last paragraph of Freeman's contract with Palladino on behalf of Kelly states as much. It says that he agrees to hold confidential and not reveal any third party the contents or subject matter of this agreement, and the terms of Freeman's contract are telling. This is a hard document that you can consider when evaluating Freeman's testimony. For one, Freeman told you there was no way he was going to turn over the tape to Palladino and Mcdavid without something in writing. And Freeman has been around the block. He knows how to use leverage. If someone's going to ask him to do something illegal, something off the books, he is not going to take them at their word. He's going to get an agreement in writing. And Freeman testified about that. He told you how he met with Mcdavid and Palladino in Kansas City and brought a contract with him. He had drafted up a contract saying he would recover the tape for $1 million. Instead, Palladino said they would put together a contract for Freeman, which is what they did. They put together this contract here, Government Exhibit 320, and gave it to Freeman. And under this contract, Freeman would get paid $100,000 plus up to $40,000 for expenses. And Freeman testified that he signed this contract, but he signed it with the understanding if he got Mcdavid and Palladino the stolen item that they were looking for, he would actually get paid $1 million. So the contract here was prepared by Palladino, and the term that he used to describe the stolen item was performance tape. So let's talk about that for a minute. R. Kelly was a superstar. So what is the concern about a performance? A stolen performance tape? Why are they paying Freeman a large sum of money to recover a stolen performance tape? The term performance tape was used because everyone in that room on that day knew that they were talking about something else. They were talking about a tape with Jane, the tape that Lisa had stolen. And you saw the same language used in the polygraph consent form for Freeman. And this was the form prepared by John Herlock, the polygrapher. And he testified he was instructed to write down performance tape on the form for Palladino. So going back to Freeman's contract, again, when you look at this document, Freeman's testimony makes sense. You know for a fact that Freeman was paid way more than $1,000 for returning the tape of Jane to Mcdavid and Kelly. The tape that contained the scenes of Jane and Kelly in the bedroom and on the checkered floor. Another fact that cannot be disputed, Freeman had the tapes. He kept copies as insurance, so he had leverage to keep going back to Mcdavid for money. Money that he received from Mcdavid and Kelly in 2001, 2003, 2005, 2008, 2009. Freeman was all about the money. He insisted on a contract. He filed multiple lawsuits to enforce it. He followed Kelly around for years trying to collect, trying to profit off of tapes depicting Jane's horrible abuse. If Freeman had marched those tapes right over to the Chicago Police Department in 2001, when Jane was 17 years old, things could have been different. It's possible that Jane and her family could have been spared years of living with these secrets, living with the lies that Jane told you from that witness stand were exhausting. But no, Charles Freeman is not thinking about Jane. He saw those videos. He was not thinking of a girl who says over and over on video 2 that she's 14 years old. And he told you that. When Mcdavid's lawyer confronted Freeman about his lack of concern for the girl on the tape, Freeman's response was, "I had a job to do." And that says a lot, ladies and gentlemen. It cements the entire reason that Charles Freeman was the guy that Kelly and Mcdavid went to in 2001. They chose him. They chose Freeman because they knew he would do the job for the right price. They chose Freeman because they knew he would do the job and not go to law enforcement. To quote Freeman again, he told you, plain and simple, after he got this tape as requested by Kelly, Mcdavid, and Palladino, He did not go to the police because the police were not going to pay him $1 million. It's reprehensible, but it is the truth. The government called Freeman as a witness in this case, but make no mistake about it, we did not choose Charles Freeman. These men did. Because you see, they were trying to get back videos of child pornography and thwart an ongoing child pornography investigation by CPD. So, no, they didn't call an upstanding citizen to get those tapes back. They didn't call somebody who's liable to go to the police. No, they called Charles Freeman. And that's exactly what they did back in 2001. And sure, they want to distance themselves from him now, refers to Freeman as a lowly t-shirt salesman who extorted them because that's the narrative that suits them now. But back then, when Kelly was being investigated for abusing Jane, they knew that Freeman would do this job for money and he would do it while keeping his mouth shut. So, in addition to what was going on in Kansas City with Charles Freeman in 2001, there was information about a videotape of Jane swirling around Chicago in 2001 as well. And Jane testified that in late 2001, she learned from her Aunt Stephanie that a tape of her and Kelly had leaked. She testified that she was extremely scared after learning about that tape. And there are two important points to keep in mind for late 2001. First, Jane was only 17 years old. She was still a minor. And all of the videos of Jane, videos 1, 2, 3, and 4, were filmed in Kelly's George Street house. So what does Kelly do in December of 2001 when Jane is 17 years old? He sells the George Street house. Kelly sold his home. And here it is, Kelly's house at 1010 West George Street, the home that he had customized with R. Kelly murals, the home that had his own baseball gym, and a shark tank, and a barbershop. In December of 2001, Kelly sold this home to a man named Matthew Holzheiser, who testified in the case. And during his testimony, Holzheiser used this exhibit, 112-E, to describe the layout of the George Street house. The top left was the shark tank, the right side was the barbershop, and Holzheiser testified about what other rooms looked like in the house when he moved in.
Thank you very much, Tanya. Go ahead and take a break. CJ, can you jump back in for us, please?
Sure.
Thank you.
And he bought the home from Kelly and moved in early 2002. You saw photographs of what the house looked like when Holzheiser moved in. The living room, or the room where video 1 and video 4 were filmed. The scene where video 2 was filmed. The scene where video 3 was filmed. And it's a good thing that Kelly sold the home when he did, because you all know who comes knocking at the door in February of 2002. Detective Everett. A copy of video 1 had made its way to the Chicago Police Department, and CPT wasted no time in getting over to 1010 West George Street to investigate and take photographs. Now, Robert Kelly was gone from the house, but the evidence where he sexually abused Jane was not. At the time that CPD took those photos of the house in February of 2002, Jane was 17 years old. She was still a minor. And the fact that Kelly sold before Detective Everett goes over there tells you without a doubt that Kelly and his team were already working together to cover up the evidence of his abuse of Jane before February 2002. In fact, the month prior, January 2002, was a critical point in the time for Kelly and Mcdavid. It's when they approached Jane's parents, Susan and Brandon, about the video of Kelly and Jane in the log cabin room. In January 2002, Daryl Mcdavid and Robert Kelly had a meeting with Jane, Susan, and Brandon at a hotel in Oak Park. In this meeting is where things get really serious, because the rumors about the log cabin tape of Jane, video 1, were true. Jane testified that before going to the hotel for this meeting, Kelly confirmed with her that the tape was out there. It wasn't just a rumor. It was out there, and they needed to come out with a plan fast. So, does Kelly take this on all by himself? Does he assemble Jane and her family so he can talk to them alone? No. Kelly cannot possibly manage that situation all by himself. He needs his team. He needs Daryl Mcdavid. And Jane testified it was Mcdavid who set up the meeting at the hotel. Because again, Jane had already talked to Robert Kelly before going into that meeting. He told her that the tape of them was out there. He told her that they needed to meet and get Jane's parents on board. Kelly and Jane. Kelly told Jane that Mcdavid was going to be involved in the game plan that was about to take place regarding that, what Jane referred to as the approach. Jane was terrified going into this meeting. Her parents were finally going to find out the truth of what had been going on the past 3 years with her godfather. And Jane could not recall whether Mcdavid was actually at the meeting at the hotel. She said she knew Mcdavid had set it up, but Jane could not remember if he was there. Jane's mom, Susan, however, testified that Mcdavid was there. Susan stated that the people at the meeting included her, Brandon, Mcdavid, and Kelly. By both Jane and Susan's accounts, this meeting was extremely emotional. It was a meeting they both remembered vividly, albeit from their own perspectives. For Jane, this was the moment that her parents were going to find out this huge secret that she had been keeping from them for 3 years. And Jane described in detail seeing her dad and Kelly talking, and her dad hysterically crying and upset. And Kelly crying and dropping to his knees and apologizing profusely and begging for her dad's forgiveness. Jane remembered her dad was angry, and he told Kelly, "I can't help you." During this meeting, Jane told her parents that she loved Kelly and that Kelly loved her. And Jane begged her parents not to go against Kelly, not to turn on him. And Jane described how her dad was trying to leave the room, but that Kelly followed and continued to plead with Brandon. Her dad was not having it. He kept saying, "I can't help you." And Susan, she also testified about what happened at this meeting at the hotel in Oak Park. And Susan testified that Kelly was apologizing and crying, and her husband Brandon was very angry and crying. And she was crying, and she was upset the allegations were true. Kelly had sex with her 14-year-old daughter. And Susan testified that Mcdavid was at this meeting. It wasn't just Kelly. It was Kelly and Mcdavid. And Susan remembers that because this was the meeting she found out that R. Kelly was abusing her daughter. Susan knows what adults were in that room when she found out that news. And Susan testified that it was Kelly who told Brandon and Susan, "You're with us or you're against us." With us. With Kelly and Mcdavid. With Kelly and his team. And Susan interpreted this to mean that they were going to harm her family if they did not get on board with what they wanted to do. And Kelly told Susan, Brandon, and Jane that they had to leave town right away. So they packed up their bags and left on a trip that was paid for by Kelly. And I will talk about that trip more in a minute. But first, it is important to emphasize Mcdavid was at this meeting in the hotel in Oak Park, and Mcdavid observed what happened. He knew full well how serious the situation was for his boss, Robert Kelly. Mcdavid knew why everyone was upset and shouting and crying. Mcdavid knew that the entire family was about to get out of town. And not just out of town, out of the country for multiple weeks. And when you look at all the circumstances here, you know that Mcdavid appreciated the gravity of an investigation involving Kelly and Jane, who was only 17 years old at the time of this meeting at the hotel. And any other alternative explanation just does not make sense. If the log cabin video is a fake or the allegations are not true, why on earth would Kelly and Mcdavid want the family out of the country? And Mcdavid and Kelly want them gone if Mcdavid and Kelly want them gone so the family doesn't have to be exposed to some of the bad publicity to the media, why is Kelly on his knees begging, crying, and pleading for forgiveness? No. The purpose? Why would he be acting that way if the purpose of the meeting was just some bad publicity? It's because the purpose of that meeting was to get the parents on board. They needed to be on Kelly's team. They were Jane's parents. Jane was a minor. She was a minor at the time of this meeting. And think about it. If Jane testified at that time, back when she was 17, she was with Kelly 100%. She was on his side. She didn't want anything bad to happen to him or her own family. But her parents, that's a different story. Kelly and Mcdavid need the parents to get on board with this. And they used Jane and this meeting and the trip that followed to get them on board, to get them on Kelly's team. And it was important to get them out of town right away. It was not to avoid the media storm about some fake video. It was important to get them out of town so that Jane had time to be with her parents and persuade them to get on board with what was about to be a criminal prosecution of Robert Kelly's abuse of Jane when she was 14 years old and documented by him in the log cabin room. Kelly and Mcdavid wanted them out of the country so that Jane could help convince her parents to be on Kelly's side. Kelly and Mcdavid wanted them out of the country so they would be isolated from law enforcement, from others who might get them to change their minds about going with Team Kelly. And the plan worked. There were actions. Jane showed her parents that she would completely cut them out of her life if they took her away from Robert Kelly. On January 21st, 2002, Jane, Susan, and Brandon were sent out of the country. You saw documents related to the Bahamas trip that Brandon, Susan, and Jane were sent on during this very same time frame that Detective Everett was reviving in the investigation of Jane. And who else went to the Bahamas at that very same time? June Brown. You also saw travel records and documents showing that after the Bahamas, the family went to Mexico. And who else went to Mexico at that very same time? June Brown. You can use your common sense here, ladies and gentlemen. Is it merely a coincidence that June Brown is at both locations at the same time? Is it merely a coincidence that June is at the same locations with Jane and her family during the time that Jane and her family were sent away by Robert Kelly? Now, remember, Jane and her family were sent away because the investigation was breaking open in Chicago. This was a critical point in time for Kelly. And who was dispatched to both locations? June Brown. This right here is evidence of June Brown's knowledge of the situation with Jane. Think about the risk of sending Brown to both of those locations with the family if Brown doesn't know what's going on. And Jane told you while she was on these trips, she remained in contact with Kelly and that Kelly kept asking her how her parents were doing. This 17-year-old girl who was tasked with getting her parents on board by her abuser. What an enormous weight she was carrying at that time. And she did it. And she did it because at that point, she couldn't imagine her life without Kelly. And to show her love and loyalty to him, Jane got a tattoo while she was in Mexico. It was of Kelly's first name, Robert, inside of a heart. In late February, Jane, Brandon, and Susan returned to the United States. After Susan, Brandon, and Jane returned to the United States, Jane testified that she told Robert about the tattoo she got of his name while she was in Mexico. Jane, a 17-year-old teenager, was excited about that tattoo. And Kelly, a 35-year-old adult who was being investigated for child sexual abuse of Jane, was not. Kelly enlisted June Brown to take Jane to a house where she got that tattoo covered up. Let me pause right here and talk about this tattoo situation for a minute. June Brown, who the travel records show was in Mexico at the same time as Jane, is later asked to take her to get the tattoo she got in Mexico covered up. And June Brown does this in early 2002, when the media frenzy about Jane and Kelly is in full swing. CPD and the state prosecutors are investigating. Kelly was about to get charged with child pornography related to a video of Jane. And June is taking her to get a tattoo covered up? Use your common sense here. This is the type of evidence that shows June Brown knew what was going on. He knew who Jane was, and he's taking her to get a tattoo covered up. A tattoo she had literally just gotten in Mexico and that needed to be covered up immediately. Meanwhile, Kelly and his team were dealing with ongoing grand jury investigation because even if they can send Jane, Susan, and Brandon out of the country for a while, this situation was not blowing over anytime soon. And the Cook County State's Attorney's Office was issuing grand jury subpoenas. Jane and Susan testified about the specific instructions they received from Kelly about how to deal with the subpoenas. Deny, deny, deny. Kelly told Jane that she needed to be firm in her denial that anything was going on with Kelly. And Kelly told Susan to deny that it was Jane on the video. And Kelly hired them an attorney to sit in the grand jury room with them while they gave their testimony. And Jane and Susan did what they were told. Their lies, their false statements were entered into the record for the state grand jury investigation. Susan testified that she went along with Kelly's plan because she was scared of Kelly. She was scared of what he would do to their family if she told the truth. If she told the prosecutor that it was her child on that tape. So Susan lied. And these are portions of Susan's grand jury transcripts that were admitted as Government Exhibit 303. She falsely testified that she did not recognize Jane and she did not recognize Kelly. Jane told you that she fell in line as well. She lied before the grand jury. And these are portions of Jane's grand jury transcript that was admitted as Government Exhibit 301. She testified that he never made any sexual advance on her. And Jane testified she did not recognize the girl in the photo, which was the still photo they showed her from the log cabin video. And Jane testified here in this trial that she lied back in 2008 because she was afraid to expose Kelly. She was afraid of what might happen to her own parents. She told you that from when the state prosecutor showed her the photo from the log cabin video, Jane felt shame. And she testified that she did not want that person to be me. Despite the lies in the grand jury, Kelly was still charged by the Cook County State Attorney's Office with child pornography offenses to the video of Jane and Kelly in the log cabin room, video 1. So Kelly was charged and everyone on his team are on high alert. Because remember, not only do they have to deal with the pending prosecution related to Jane's video 1, but they're already dealing with Charles Freeman back in 2001, and they knew that there were other videos of Jane and Kelly, videos 2 and 3. And let's be clear, if videos 2 and 3 get into the hands of law enforcement, Kelly's situation would get even worse. And do you know who realized how bad things would get for Kelly if information about videos 2 and 3 got out? Charles Freeman. And Freeman used that to his full advantage and to keep Mcdavid current on his payments that Freeman was promised. So in 2002, when Freeman did not get paid what he was owed under their agreement, he filed a lawsuit against Robert Kelly. And Freeman filed his lawsuit in mid-2002. After Kelly was charged by the Cook County State Attorney's Office with child pornography claims related to video 1 of Jane. Freeman testified that this lawsuit was settled, and all of that, of course, makes sense. Think of the timing here. Mid-2002, Kelly had been charged. Do you think Mcdavid and Kelly want to litigate Freeman's lawsuit related to other videos of Jane? The videos of Jane on the black and white checkered floor? The video of Jane in the bedroom? Of course not. They needed to handle Freeman. They needed Freeman to stay quiet. They needed Freeman to stay out of the courts and out of the public eye. So they made Freeman's 2002 lawsuit go away. They paid him $150,000 to settle it. And as Freeman testified, Mcdavid told him they would continue to pay him $100,000 every other year up until Kelly's trial was over, so long as Freeman stayed quiet and did what he was told. Freeman would then receive the balance. So moving forward in time to 2003, Freeman testified Mcdavid paid him $100,000 pursuant to their agreement. Later in 2003, beginning of 2004, Freeman testified Mcdavid called him about another tape, and he asked Freeman to come to Chicago, and Freeman did. Freeman met with Kelly, Mcdavid, and Brown in a room at Kelly's studio, and it was then that Kelly and Mcdavid told Freeman there was another tape out there involving the same girl that was on video 2 and video 3, Jane. But this tape was a threesome between Jane, Lisa Van Allen, and Kelly. And Mcdavid told Freeman during this meeting that they believed that someone in Kansas City had this threesome tape, which, as you know, is true. Keith Morrell had the tape that Lisa sent him around 2000.
Thank you very much, CJ. I'm going to let you get a break. Leslie, will you please jump in?
Sure. And while Keith had been hanging on to this tape for Lisa, he definitely didn't keep its existence a secret. You heard Keith testify about he showed the tape to multiple people, including other members of the group Talent, his girlfriend. So it makes sense that word about this other tape of Jane, Kelly, and Lisa, made its way back to Kelly's team. And at this time, Kelly is under indictment for child pornography. So, do you think Kelly and his team would just ignore rumors about additional tapes? No. First of all, Kelly knows full well there were other tapes of Jane. He's the one that's filming them. It's not just video 1 that the state prosecutors have. He's the one filming them and storing them in his gym bag. And he's the one who notices when one goes missing. But is Kelly the only one who's going to deal with this mess? Absolutely not. He's going to rely on his team. And in late 2003, early 2004, the team decided to contact Freeman again. And the defendants would want you to believe that it would make 0 sense to contact Freeman again. Freeman was still collecting on his prior contract and had no signs of letting that go. Exactly the opposite is true. It makes complete sense to go with Freeman again. First, Freeman is already in. in on the inner circle of this situation. He knows what's going on, and he has not gone to the police about anything. So as long as Freeman is getting paid, he is at the disposal of Kelly and his team. And you know there is no shortage of money when it comes to Robert Kelly. He was a megastar. He was rich. He had the means to pay people like Charles Freeman and others to keep his abuse of children a secret that would ruin Kelly forever if it came out. And yes, that is worth $1 million. And they were already paying Freeman a lot of money at this time. So it makes complete sense that they'd go back to Freeman. And Freeman told you straight up, he was committed to keeping these tapes from law enforcement, with one exception. If law enforcement ever came for him, he was going to tell. And that's exactly what happened in 2019. Again, Charles Freeman is disgraceful. You do not have to like him. You just need to view what he told you in light of all the other evidence in this case. And when you do that, you will see that his testimony is supported by other evidence in this case. Now, after the studio meeting, Freeman returned for a second time, a second meeting. And again, we're still in the 2003-2004 timeframe. Freeman met with Mcdavid and Kelly in a studio room at Kelly's house in Olympia Fields. And during this time, Mcdavid played a portion of video 4 so that Freeman could see what video Kelly and his team were looking for. Now, you might be asking yourself, how can Mcdavid be showing Freeman a portion of the very same video that they were looking for? And the answer to that question is something that illustrates the magnitude and the complexity of the situation that Kelly and his team were dealing with back then. The videotapes. Tapes can be copied. They can be copied in whole, they can be copied in part, and they can be copied again and again. And you heard Freeman. As soon as he got his hands on that tape in Georgia in 2001, he went to Walmart and he bought a pack of tapes and he made as many copies as he could. And he still had copies in 2019. Keith Morrell, he too made a copy of Lisa's tape before he left for Chicago in 2007. Tapes can be copied. And once a tape is out there in the universe, there are limits to what Kelly and his team can do to control the number of copies being made. But that doesn't mean they didn't try. So let's get into the events of 2007 now. In 2007, Lisa learned that the tape she had taken from Kelly's gym bag in 2001, the tape that videos 2 and 4 on it was being shopped around. And of course, this concerns Lisa because not only is she on the tape, she is on the tape with Jane, who Lisa knows was only 14 years old at the time that Kelly filmed the three of them having sex. Lisa cannot have that tape come out, and she knows Kelly certainly doesn't want the tape out either. He was getting ready for his child pornography trial related to video 1. So this kicks off a very critical time in the conspiracy. This is when Kelly's team springs into action and the cover-up becomes less laser focused on Lisa and Keith and the threesome video of Kelly, Lisa and Jane. After Lisa heard the tape of her, Kelly, and Jane might be sold, she called Keith. She called Keith to talk to him about getting the tape back from him, and Keith said no. Lisa and Kelly then have a call about the tape. Kelly told Lisa to come up to Chicago, and within a matter of days, Lisa traveled to Chicago and met with Kelly. They met at Kelly's house in Olympia Fields. This was the meeting in the pool room that Lisa told you about. Kelly told Lisa that he would pay $250,000 to get the tape back, and Kelly was successful in getting Lisa on board and getting her to agree to work with his team. And after that conversation, Kelly directed Lisa to deal with Daryl Mcdavid going forward. Kelly did his part, get Lisa on board. Now it's time for Daryl to do his part, buy those tapes back. This is how Kelly and Mcdavid's arrangement worked. This is how they handled things back in 2001 with Charles Freeman. Remember, Kelly makes the initial call, and then after Freeman told Kelly that he was willing to get the stolen tape, Kelly told Freeman to work with Mcdavid going forward. When you have a conspiracy like this, the members of the conspiracy do not have to know about or be present for every single meeting or every single action that was taken in furtherance of the conspiracy. That's not what the law requires. And one of the instructions I expect you will get is this. To be a member of a conspiracy, a defendant does not need to join at the beginning. He does not need to know all of the other members or all of the other means by which the illegal goals of the conspiracy were to be accomplished. And like I discussed at the beginning of my argument, a conspiracy is an agreement to commit a crime. In determining whether there is a conspiracy, you can consider all of the circumstances. And I highlight this here because Kelly's meeting with Lisa is one of the many things that still illustrates how this conspiracy with Kelly and Mcdavid worked. Kelly and Mcdavid were working together to obstruct the Cook County prosecution involving Jane and to conceal the other tapes of Jane from coming to light. As far as the threesome video 4, was concerned, it was Kelly's job to meet with Lisa in person to get her on board. And after Kelly assured Lisa was going to cooperate with their plan, he handed her off to Daryl Mcdavid, who would handle the business of getting the tape back from Keith. But first, Lisa needed to be questioned. Lisa was the one who took the tape to begin with, and Kelly and Mcdavid need to get a sense of the scope of the damage she caused between the time she took the tape around 2000 and 2007. So, as a first step, they had Lisa take a polygraph. That's on March 23rd, 2007. Here are the records. The polygraph was requested by Kelly's attorney, Ed Jensen, who was representing Kelly in the pending child pornography case. The exam took place at the polygrapher's office, Lawrence Beaumont. He came and testified about these documents. And Lisa testified about this polygraph examination in March of 2007. She told you she met up with June Brown, and June drove her to the office. Lisa told you that Daryl Mcdavid was there with the polygrapher. And Lisa testified she had to take this first test because they wanted to know the tape existed. Lisa told you she was not expecting to receive money at this initial meeting because they had not received the tape back yet. We also have the travel records that were entered into evidence showing that Kelly's company, Base Productions, made the travel arrangements for Lisa to get to Chicago in March of 2007. Now remember, as Lisa is making these initial trips to Chicago in early 2007, the tape is still with Keith Morrell in Kansas City. The stakes are high. If this situation is not handled correctly, Kelly and Mcdavid risk having even more copies of this tape being made. This is very serious. This is a very serious situation for Kelly, and it was treated as such. And what unfolded in April of 2007 consisted of multiple flight and hotel bookings to get Lisa and Keith to Chicago, multiple polygraph examinations, and $200,000 in cash being handed over by Mcdavid to Keith and Lisa in exchange for video 4. So let's go through this piece by piece. In April 2007, Keith Morrell knows that Robert Kelly wants the threesome video back. And he knows that because he testified that he received a call from Daryl Mcdavid, who told Keith that he knew Keith had a copy of the tape. And this call from Daryl is followed up by a call from June Brown regarding travel arrangements. Before leaving Kansas City for Chicago, Keith decided to copy a snippet of the threesome video. And Keith's plan was to leave the original video with Lisa, from Lisa back in Kansas City, and travel to Chicago with the snippet. Also, before leaving Kansas City for Chicago, Keith decided to talk to his friend Charles Freeman, and Keith and Freeman both testified about this meeting. Keith told you he wanted to talk to Freeman to get his advice about going up to Chicago with the tape. And during this meeting with Freeman, Keith gave the full-length version of video 4 to Freeman, who took the tape up to an office building so that Freeman could look at the tape. And Freeman also told you about this meeting. Freeman told you that he wanted to see what Keith had. He wanted to get in on the action for this tape. And Freeman testified he tried to copy the threesome video to his phone, but it really didn't work. And he ultimately let Keith go through with the deal that Keith already had in place with Daryl Mcdavid. And here's the date of Keith Morrell's first trip to Chicago to meet with Mcdavid and Brown about the video that Lisa had sent him all those years earlier, April 18th, 2007. We have the travel records that show multiple rooms booked at the Westin by June Brown. Records that the government subpoenaed from the Westin itself showing those rooms were booked by June Brown. Credit card charges for the hotel room bookings. As you know from both Keith and Lisa's testimony, the plan is for the meeting on April 17th the plan for the meeting on April 17th was for Keith and Lisa to return video 4 to Mcdavid and get paid for doing so. Kelly had told Lisa he would pay her $250,000 for the tape. But you know that Lisa later learned that Mcdavid never intended to pay the full $250,000 up front. No, Mcdavid was going to withhold $50,000 of Lisa's portion until after the child pornography trial was over. Daryl Mcdavid didn't want to take any chances with Lisa. She took the tape to begin with, and they viewed her as a liability. So, Mcdavid wanted to incentivize Lisa to stay quiet, not just in 2007, but until the trial was over. And here's the check that Daryl Mcdavid wrote to Milton Brown, $200,000 on April 17th, 2017. And I want to pause here because this is very important. The fact that Daryl Mcdavid withheld $50,000 from Lisa until Kelly's trial was over shows you that Daryl Mcdavid knew what was on the threesome video. This is not a regular porno, as the defense counsel likes to call it. No, if it was a regular porno of consenting adults, a sex tape of Kelly and his wife Drea, then why the need to hold back money from Lisa until the trial involving Jane is over? If it was a regular porno that would embarrass Mr. Kelly and hurt his reputation, they would just pay to get it back, plain and simple. Here's some money, give me my sex tape of me and my wife back. But that's not what was going on here. There was much, much more at stake. The video that Kelly had was a video of Lisa, Kelly, and Jane. A video that could not see the light of day while Kelly's child pornography trial was going on. A video that could not see the light of day ever. Because if it did, Kelly would face another investigation and more criminal charges. And Mcdavid knew the urgency with which he needed to deal with the threesome tape of Kelly and of Keith and Lisa. Get the tape from Keith and Lisa. So he wrote this check right here for $200,000 and had June Brown cash it the very same day. They needed to have everything ready for that meeting with Keith and Lisa. As Keith testified, Daryl told him he wasn't playing and he had shown Keith the cash to prove it. Together, Mcdavid and Brown got the $200,000 cash, brought it to the Westin Hotel on April 17, 2007. Before we get into the things that happened at that meeting, when you look at this check, you should ask yourselves another question. Why cash? Why bring $200,000 in cash to a meeting if you're recovering an embarrassing but legal video? Why not send a wire? Write a check to Keith Morrell. Why is it necessary to use cash here? I'll give you a hint. Because what they were doing was not legal. They were buying back a tape of Kelly abusing Jane when she was 14 years old. That's why. And so, the group had assembled at the Westin Hotel. He told you he handed the snippet he copied to Mcdavid, and that Mcdavid and Lisa went into another room to watch it. And Lisa confirmed that. She told you she went into the bedroom area with Mcdavid so they could watch the tape separate from the others. And Keith took his polygraph test. It's right here, the record showing it was taken at the Westin Hotel. And as you know, Keith failed this exam because he had made a copy of the tape before coming to Chicago. After he failed, Mcdavid showed Keith the 2 bags of money. Mcdavid then gave Keith and Lisa $20,000 each in cash, told them to come back to Chicago with all of the copies of this tape. And he told them he was giving them $20,000 so that they would know that the rest of the money would be there for them once they did that. And Lisa said the same thing. Let's stop and think about that for a minute. Mcdavid gives Keith and Lisa $20,000 in cash, and they had not even followed through on their end of the deal. $20,000 each. Wouldn't you think that Daryl Mcdavid would be at all concerned that Keith might take the $20,000 and stay in Kansas City, or that Lisa would do that as well? Take the money, stay there? Well, that was not as much of a concern here because cash wasn't Daryl Mcdavid's only leverage here. He also used threats, and you heard about those, and Keith told you about that. He testified that Daryl told him straight up, if you don't come back, this guy right here will come and see you. He said Daryl was referring to the tall guy in the room, the security guy, the muscle. And clearly Keith heard Mcdavid loud and clear because he went back to Kansas City, got the tape, and immediately returned to Chicago. Here's the plain charges. He leaves Kansas City on April 19th. Looking at the timeline, Keith flew back to Kansas City and returned back to Chicago the very next day, April 20th. And here's the travel arrangements. Again, these are for the April 19th booking through April 21st. And their rooms booked at the Swiss Hotel because rooms are also needed, as you recall, for those polygraph examinations. All of these bookings were handled by Milton Brown. So, once again, the group assembles for the tape exchange and the polygraph test, this time at the Swiss Hotel. And here are the records from Lisa's polygraph. And the cover page shows that the exam took place at the Swiss Hotel. And Mr. Beaumont, the polygrapher, testified that Lisa passed this test. And Lisa testified about how Mcdavid paid her $50,000 at this meeting. As for Keith, he testified about the second meeting in Chicago on April 20th, 2007. And he told you that this time he did bring the full copy of video 4, just like the last trip. All of his travel arrangements were taken care of by June Brown. After Keith arrived in Chicago, June picked him up and took him to a different hotel. Well, he met with Mcdavid, June Brown, and the polygrapher. And Keith expected to get the big payment on this trip, and June knew that too. While Keith was at the meeting, June told Keith that Keith had the golden egg, which Keith understood to mean that June knew Keith had the tape and was about to get some money for it. And once again, Keith gave the tape to Mcdavid, who required Keith to take another polygraph examination. And here are the records. Required.
I'm sorry, y'all. I was talking. It was on mute. I was asking, do y'all need a 5-minute break?
Yes.
Okay, let's take a break. We'll come right back, and then we'll read for a little bit longer. And we'll close it out for the night. I would assume that Tanya with the sleepy tea is already asleep. Tanya, you sleep?
Oh, I had faith in her too.
I know.
I was still on mute. Like, come on, Tanya, you can do it, girl.
Peace out. All right, y'all. Let's take a 5-minute break, and we will come right back. Okay.
All right.
Okay.
All right. Thank y'all. Do this here. Let's do.
One small voice in this great big world, with all of the confusion, how can anyone be heard? One hand all alone, reaching for the sky. Sometimes it seems so pointless, but still I have to try. I still believe in miracles, 'cause here I am with you. Together we can make the dreams come true. Here you are, standing next to me. Oh, what used to seem impossible are now possibilities. Oh, when I'm weak, I know you are strong. When I'm standing here beside you,
All right, y'all. We back.
Atmos, was that you?
Yeah, that's my song.
Oh my God, Atmos, that song is beautiful.
Thank you. It's called it was written by a guy named Jeff Brainer.
Okay.
And he wrote it and he said Atmos, will you please sing this? And
my.
yeah, so that's it's called Together We Can. Yeah, thank you. I appreciate it.
Is it on Apple Music?
It will be.
Okay.
It will be very soon.
Okay.
But I will let you know exactly when it is. But I
Let us know so we can support it.
Please do. So I would love to have that song. That song is beautiful.
Thank you so much.
Bringing back the bridges. Come on, man.
That's right. That's right.
Yeah.
It's a coming together song, right? It's a song.
It is.
We can do this together. Okay.
It also seemed like it was a little bit of a wedding song too. Like
it's a wedding song. It's one of those. It's the new We Are the World. Together we can. You know.
Right.
I mean, just one small voice in this great big world. With all of the confusion, how can anyone be heard? One hand all alone, reaching for the sky. Sometimes it seems so. I mean, man, look, that's a deep song.
It is beautiful. Please let us know when you release it.
Yeah. Also, shout out to you for sounding good on Zoom. Because that is important. Like, that means you can actually sing. You sound good on Zoom.
Absolutely.
I can hold a note or two. I can hold a note or two.
You can do a little ditty.
A little bit.
Yeah.
Ladies, we're gonna read a little bit more, and then I'm gonna let y'all get some rest. But y'all are doing an excellent job. Thank you so much. CJ, if you don't mind jumping back in.
Yes. Previously, I was fighting with my dog over my chicken strips. I was just like, oh my God. The struggle. Okay. What line?
We're going to start at line 3.
Okay. Once again, Keith was asked during the exam whether he made any copies of the videotape. And Keith passed the exam this time. And he told you Daryl Mcdavid gave him a hug and paid him $80,000 in cash. So much cash that Keith told you how Mcdavid and June arranged for a car service to take Keith and his bag of money back to Kansas City. Kelly and his team got what they needed from Keith Morrell, but they weren't done with Lisa. Lisa returned to Chicago for another meeting with Mcdavid in July of 2007. And this time, Lisa had to make her own travel arrangements. In their view, Lisa was the one that caused all of these problems. She's the one who took the tape in 2000. And from that point, they were chasing down tapes from Georgia to Kansas City. And Lisa was required to take a third polygraph examination at Beaumont's office. And here it is, to the forms. She failed this exam. And after she failed, Mr. Mcdavid let Lisa know exactly how he felt. She had cost Mcdavid and Kelly hundreds of thousands of dollars. There could still be other copies of those tapes out there. And Mcdavid told Lisa that they should have murked her from the beginning. And Lisa understood that to mean that they should have killed her. Killed her over tapes that man, Robert Kelly, filmed. Tapes that Kelly filmed of him abusing Jane. Mcdavid said this to Lisa because she was the person who stole the tape from the gym bag and put everything at risk for Kelly. She was the cause of all these problems, getting the tapes out there and costing them lots of money. And after telling Lisa they should have murked her, Mcdavid told Lisa she needed to make a statement denying that she ever had any sexual relationship with Jane. And Lisa did as she was told. She was scared and upset, but she did what she was told. And before she left the lawyer's office that day, she told Mcdavid she was going to tell Kelly what happened. The threat that he made to her. Mcdavid told Lisa not to bother Kelly already knew what was going on. Lisa could not believe that she was expendable to them because up until that point, she had been working with Kelly and Mcdavid to get those videos back. Her interest was aligned with them. She didn't want the tapes out, especially since it involved a minor. The same minor that Kelly was being prosecuted for in Cook County. But something changed after that meeting in Chicago. Lisa changed, and she decided to cooperate with the state, and she testified at Kelly's 2008 child pornography trial. And at that trial, Lisa testified about how she met Jane in the log cabin room. She testified about the log cabin threesome video with Jane, video 4. That was Lisa's under oath testimony in 2008. And that was her testimony here in this trial. And Lisa told you about who she saw at the courthouse in 2008. These 3 defendants right here. Kelly, of course, he was the defendant, accompanied by his team, Daryl Mcdavid and June Brown. And when you look at Lisa's testimony about what happened in 2007, in light of all the evidence in this case, including her prior consistent testimony in 2008, you know you can rely on what Lisa told you. That Kelly and Mcdavid contacted her about getting the video back from Keith. That Mcdavid watched that video to make sure they had the right one before he forked over hundreds of thousands of dollars. And that it was her and Jane on that video, which again tracks what Jane told you about the threesome video. Lisa has now put herself through public testimony and rigorous, personally embarrassing cross-examination twice. You saw Lisa's demeanor up there. You saw how painful it was for her to talk about what happened with Jane, how it haunts her to know that Jane was only 14 years old at the time they had those threesomes. The shame and embarrassment she feels. Is that the demeanor of someone who wants to be here? Is that the demeanor of someone who is seeking money or fame? The fame that all of this has brought Lisa is a lifelong Google search history of someone having sex with a minor. The idea that Lisa's coming to this courthouse to testify falsely about Mcdavid and Kelly is ridiculous. There are some inconsistencies in Lisa's testimony over the past 14 years, but that is not a reason to discredit Lisa's testimony at this trial, because on the core issues, she is consistent. And the fact that Lisa has immunity in this case, just as she did back in 2008, doesn't change that. Yes, Lisa and other witnesses you heard from that have immunity from prosecution were given immunity in return for their truthful testimony and cooperation with the government. And you will be instructed to consider testimony from someone who has the benefit of immunity, that it must be considered with caution and great care. But in doing that, you have to keep in mind that they have immunity for truthful testimony. And looking at Lisa as an example, the truth included admitting for many years she incorrectly believed that she was 17 at the time that she first met Kelly. The truth is, she had actually just turned 18 when she met Kelly at that video shoot. She was cross-examined about her prior statements about her age and other topics as a way of challenging her credibility. But inconsistencies do not mean that Lisa was lying about her experience with Kelly and Mcdavid. There are several things that show you that Lisa was right. And let's go over a few of them. Lisa's testimony about video 4, the threesome video, as we already talked about, is confirmed by Jane's testimony about that video. Lisa's testimony about video 4 is confirmed by her prior testimony at the 2008 trial, where she testified about how she met Jane and how video 4 was filmed by Kelly. Lisa's testimony about taking the tape containing videos 2 and 3 and 4 matches up with the other evidence in that case. Lisa told you she took the tape from Kelly's gym bag, put it in the VCR, and then saw 2 videos of Kelly and Jane as she was looking through the video. Lisa described those videos, the bedroom scene and the black and white checkered floor, videos 2 and 3. And Lisa's description of what she saw on that tape is consistent with how Freeman described the videos he recovered for Mcdavid, Kelly, and Palladino, and is consistent with the videos that you saw here in court. And you know from Lisa's messages with Keith back in 2018, before Freeman turned in videos 2 and 3 to law enforcement, that she told Keith about how the girl in the video was talking about how she was 14 in that video. Aside from her testimony about the videos, Lisa was right about other things that she told you. She was cross-examined about not having a driver's license at the age of 18, and she was accused of lying about not having identification to get to Chicago to see Kelly in 1998. When you look at the records from the state of Georgia that were introduced, they confirm that Lisa was right about that. They show that Lisa did not receive her first state ID until October 1998. It was 1 month after she met Kelly and 4 months after her 18th birthday. Lisa testified she lost that ID and later got a driver's license. And again, the records back her up. They show she got her first driver's license in July of 1999. And I go through all of this just to say, as you evaluate Lisa's testimony and the testimony from the other witnesses, you will see that there are some differences between what a witness said at trial and what a witness said before trial and what a witness said in court. So I want to take just a couple minutes to talk about prior inconsistent statements. What should you do with those differences? You're the judges of credibility here. In considering a witness's prior statement, you can ask yourself some questions. Is it a material fact or an important act? Is it a reason to label the witness a liar and disregard all of the witness's testimony? Are there other ways to tell if the witness is telling the truth? And what else did the person say at the time or before? Are those earlier statements consistent with the testimony you heard? Again, using Lisa as an example, when you look at her testimony and ask yourself these questions, you'll find that her testimony is reliable for all of the reasons I just discussed. She was testifying truthfully at this trial, such as Jane's testimony, documents that were entered into evidence, and her prior consistent testimony in the 2008 Cook County trial. So moving forward in time, here's what the timeline looks like for 2008. First, you have the payment that Freeman told you about, where Mcdavid paid him $100,000. This was the payment Freeman received after meeting with Mcdavid and Kelly at Kelly's house in Olympia Fields. Freeman met with Kelly in the ice cream room. It was at that meeting that Kelly told Freeman they needed to make sure Freeman was not working with law enforcement. Again, timing, 2008. We're getting close to trial. Everyone's on even more high alert at this point. Freeman assured Kelly he was not. Then Kelly told Freeman he needed to talk to Mcdavid about the payment. And Mcdavid wanted to have this meeting in the pool to make sure that Freeman was not wearing a wire. Mcdavid promised they would make good on their payment, and the following day he did. Mcdavid met Freeman, and Mr. Mcdavid threw a bag of money in Freeman's car.
Judge, I think I'm getting
Oh,
a
wait.
note that some
Is it still me?
jurors might need a break.
Okay.
So I don't want to recess.
All right. We'll take a 15-minute recess, brief recess. There's a change of court reporters. Proceeding heard in open court. We're going to stop here for the night, y'all. 3710.
3710.
3710. Thank you so much. I appreciate y'all. Y'all did an excellent job. Man, 3710, 3710, 3710.
This is deep, y'all.
Very deep.
This is deep. Let me let Tanya go to sleep. But no, these when we read the closing arguments for the New York trial, it was freaking heart-wrenching. This here is even worse.
Yeah.
This is even worse because you have the star witness, which is Rashana, giving her testimony and bringing the nightmare to real life.
Absolutely.
It's just as a man, whenever it makes a man cringe, most of the time, men tend to sometimes, men not gonna side with no man over no kids. Not a real man anyway. But a lot of times, they got what they call the bro code. There's no bro code for sleeping with kids. That's
Absolutely not.
It's just sick.
Absolutely not. And to hear, we heard Jane's testimony, and it was so heart-wrenching to hear her say these things. But for them to all be for everything that she said to be put together and told like a story, it's just even worse just to hear her about being given the money ahead of time and how it made her feel like a prostitute and it made her feel lower than low. Who does that? Like the prosecutor asked, who does that?
Who does that? This guy.
Who does that? Yeah.
And I really do wish that maybe the prosecution, maybe Miss Pizzolo should have been directing more questioning and such like that, especially some of the cross-examination when the defense was on the stand, because I don't know that Miss Apatine did us any favors, right? Especially with Mcdavid.
No, she didn't.
Again, I know it's hard because there's not anyone alive that can also say that Mcdavid was in a room, right? But it's just it's all so crazy, and also just to think like that this girl had to sit there, and I'm sure that's her first time seeing those videos in 20 years, and she had to sit there and watch all 3 of those videos.
Yeah.
That's, I don't even know, man. After having a baby,
just the idea of her having to know that those videos are out there of her, it takes so much. It's so brave of her to speak up.
It is.
It's very brave of her to speak up, because you will, although we know her name, although we don't know what she looks like, but she will forever have to live with this for the rest of her life, that she is the girl, and it's extremely heartbreaking. I just wonder how her mother dealt with that, with her mother seeing it the first time.
Well, I don't know.
Wonder how her mother dealt.
Her mother saw it in 2008, and I don't know if you were here when we read her mother, but she didn't come across fully.
She didn't act like she cares.
Mature.
Oh, really?
There was something off there with the mom. It was very ditzy, airbrainish, but not in a obtuse way. You know what I mean? Like in a legitimate, oh, you're pretty simple kind of way.
Right.
It was it was unfortunate. And I think our thought from that was, gosh, there was really no one to protect her if her mom is,
Absolutely.
basic.
She was really like wrapped in his web, and her only protection was also wrapped in his web because they were dependent on his finances to keep their family going. So this guy could do, say, control, manipulate, coerce, whatever he wanted, because he owned them. He bought them. He bought the family. He bought them. He bought the daddy. He bought them. He owned them.
Yeah, he did.
It's
He
really
did. And
go ahead.
when I'm sorry, CJ, go ahead.
No, go ahead.
When the prosecutor links Mcdavid to all of these different meetings and paying money, and Daryl Mcdavid sits up there and says, I knew nothing about it. All I did was paid lawyer money because the lawyer said to pay me the money. Of course, he did himself all the favor in the world by getting on the stand, but I still say there's some questions that Daryl Mcdavid should have been asked that he wasn't asked.
Oh yeah, I agree.
That could connect him to this. There were some questions that she just did not ask him.
I agree. So like he never. I mean, he's a lot smarter than Kelly. So he never got on a plane. I don't know how far Kansas City and Illinois are, but he never got on a plane. He never did anything. And even though honestly, even though Mcdavid was able to get off because he could, I don't understand how the jury dismissed the passport of them being in the same countries at the same time for June Brown. I don't know how they did that though. That's
the thing with June Brown, and I said this from day one. Even when I listen, let me tell you about June Brown. Although he seemed to be the least threatening of all of these folks, his lawyer was the star on this.
Right.
The way she did her pretrial motions, she got almost all of her motions got accepted by freaking Ann Donnelly.
Mm-hmm.
Actually, not Ann Donnelly, but by
Lynn Weber.
Yeah, Lynn Weber.
Well, shout out to the public defense
Hello.
teams, I guess. Public defense.
Yeah, absolutely. Shout out to the public defender because she did him a world of good.
Yeah. It really does bother me that he's like rushing through closing arguments and stuff when he was letting all kinds of nonsense go through during the trial. Be like, oh, now you want to rush them and make everybody squeeze stuff in? Like, what's one more day going to do? They're not going to snatch the courtroom from you. Calm down.
Yeah. I think he was on a time crunch, and since he's been a judge for a very, very long time, he probably is set in his ways with some things, and he probably thought that this trial should have been over a week ago.
No, I mean, I agree, but then that
yeah.
just makes you think of, like, I'm sure that he took extra care with his decisions and such for this trial, because of the heightened, like, public scrutiny. So then it just makes you think what happens to lesser defendants and how they might be rushed through, especially in a place like Chicago. You know what I mean?
Right.
Line them up, knock them down.
Corruption.
You know what I'm saying? That makes me sad.
Yeah.
Well, ladies, I appreciate y'all. Hopefully y'all did so great. Hopefully I can grab y'all tomorrow. Y'all can see us. It's pretty much this ladies, the government is pretty much apathy, and so y'all are pretty much taking over as far as the
Someone start looking for Riri now for when Bunny starts going ham. Start putting out the missing person thing now.
We're gonna have to get Tanya some what do you call them things? Red Bulls or something.
Yes.
So she can stay up.
Yeah, get her some no-dos from the gas station or whatever.
Hey y'all, thank y'all so much. I appreciate y'all. Everybody in the chat, thank you so much. Y'all have a blessed night. We will be back here tomorrow.
Thank you. Bye.
Okay,
bye,
thank
chat.
you, Atmos, for having me. Bye-bye. Bye, everybody in chat.
Peace out, y'all. Bye-bye.
Haters, all good. Thought I couldn't when I could. Woo!